Ms. Minifield, you've changed venues and microphones, haven't you? You're,
Yes, Judge, I've changed a lot.
for you.
All right, I'm showing a couple minutes till, so we'll
Okay.
hold the line a few moments.
All right, we're live on YouTube now.
Thank you.
Thank you, sir.
And Mr. Kozar, just for your information, the chat is currently enabled.
All right, my brother, I was going to ask you about that very thing, so appreciate that.
Sir.
And for those of us on the line, while remaining attentive, sometimes I multitask during this. And if you go to your, on your Zoom call, that is our Zoom call, that is restricted. If you go up to the top on mine, it's the top left hand. There is a tab that you can look at YouTube Live if you ever want to kind of get a sense of public comments or questions that are going on the YouTube station as it's being. So yeah. Comments or questions that are going on the YouTube station. So it sounds like somebody did it. There's a lag that you'll get. Yeah. And if you're not on mute, we'll catch it on our live view. So make sure you mute if you do that. It sounds like somebody did it. There's a lag that you'll get. If you're not on mute, we'll catch it on our live view. So make sure you mute if you do that. It sounds like somebody did it. I think I did it.
You just like to hear yourself, David.
Yeah, I did mute myself. I had a lag in my audio there, it looked like. Let's go ahead and get started. I know that we have had some folks report that they may have had some folks report that they may be a little late today, but we want to be respectful of the time here. And we have much rolling today and continue to have much going on. So let me, with those of us that are present, remind people that we are live on YouTube, and anyone in the public that wants to make comments on those YouTubes, we are monitoring those. And if you want to send in questions and or responses to or comments, the racial justice at lexingtonky.gov is still available to everyone. So please, we want this to be a transparent, open, and informed process. So please take advantage of those two means by which you can participate in this process as it progresses. Want to read our COVID statement. You see it there. Due to the COVID-19 pandemic, state of emergency, and Governor Beshear's executive orders regarding social distancing, this meeting is being held via teleconference pursuant to Senate Bill 150 as assigned by the governor on March 30th, 2020, and Attorney General Opinion 20-05, and in accordance with KRS 61.826, because it is not feasible to offer a primary physical location for the meeting. At this time, you should be in receipts due to the continued great support that is being offered by our mayoral staff in the person of Laura Hatfield. You should be in receipt of the minutes from our Thursday meeting, our meeting this past Thursday. Hopefully you've had a chance to review those. If so, I will entertain a motion to accept the minutes from our previous meeting that was held. That would have been Thursday, July 30th. I'll entertain a motion to approve those minutes.
So moved.
Second.
So moved by Brother Scorsone. Looks like second by Sister Queen. Any question? I have no question. All opposed? Aye or hand up. Any other? Though any opposed? Nay. All right. All right. Motion carries. I think I said opposed twice. All in approval? Aye, please.
Aye.
All right. Opposed?
Aye.
Nay. Thank you. Motion carries once it was put forth right. Thank you. So we continue to do good work. Let me just say thank you. Anyone that has watched the email traffic over the weekend knows that we're certainly putting the effort in, knows that the research is certainly being done. Those that are looking to see what our officials and committee members from LPD to Sheriff Witt to our committee members that are providing information at large to committee members that are providing information nationally and internationally that is relevant to this topic. You ladies and gentlemen are working diligently at this and we thank you. So as much as it's possible, please try to keep up with the information that's flowing, and we know that's difficult. And those areas particularly that you're most interested in, please keep up with that information. It is all available. Again, Laura doing a great job of posting everything pretty immediately to Google Drive. We are beginning to synthesize that and forming recommendations that we know are going to be helpful in our community. Last week, we had a great presentation from Dr. Potter of EKU in reference to some of policing practices, both nationally and his insights from his experiences there. We will follow up on some of that today even and look at some of the information and recommendations that are beginning to form. Prior to doing that, though, we're doing something that is actually segueing us into another component of what we knew we needed to do, and that's looking at processes of those individuals that have found themselves in the judiciary process. We're looking at knowing from the composition of this group very early on, several people on the committee and outside the committee said, we do not have public defenders represented in earnest in the group. Many of you and all of your experience have, in your vast experience, have been in or around those defense attorney positions and or perhaps even executed in that way. But we wanted to make sure that we had adequate representation. Judge Kaufman began doing research. We also looked at some of the resources of the network on this team, and we identified Mr. Damon Preston, who's with the Department for Public Advocacy, who's going to present to us today. And that's all I was going to do in the order of introductions. Judge Kaufman, you have anything to add to that before we kick it to Damon?
Just a question. I'm still seeing your screen, Mr. Cozart. There we go. Thank you. Okay, thank you.
Sorry about that.
And welcome, Mr. Preston.
Yes.
Thank you for joining us.
Thank you.
Yes, Mr. Preston, thank you. I believe that we said that you would give your presentation. We've got some time set aside afterwards for questions as well.
Great.
The format we've used is we've allowed our guests to present, and then we will come back on the end of your presentation and ask any questions or comments. So please.
All right, that sounds good. Let me.
Mr. Preston, I want to interrupt you just for a minute.
Go right ahead.
I have a question here. Who is Scott West? Laura asked that. Is Mr. West on the line?
Yeah, Scott is the deputy public advocate for DPA, and he'll be here for the answers.
That's what I thought. Okay, thank you.
All right. Let me get the PowerPoint started. I'll share my screen here. At least I hope I will. Thank you all for letting me present today. I think we hopefully can bring a perspective, not that's completely different, but that's maybe looking at some of the same information from different angles. I could speak for an hour on public defenders' view of the world, and it might be interesting to you, but what we've decided to do is just present a heavy data perspective on the criminal justice system. Most of what I'm going to present will be related to Fayette County. Some of it, because of limited data or just a particular point that I want to make, we'll go broader than Fayette County, but I wanted to look specifically at Fayette County. And so this is a look at systemic racism or systemic inequity within the system. And I think it's important, the word systemic is important. That's where your recommendations are going to come in to making a change that goes beyond individual people. None of what I'm going to say is saying that specific players have a goal of implementing racist policies. But when you look at the data, I believe it's undeniable that race does play a role in the system. And so that's what we're going to look at today. So let me just advance this here. Let me say that a lot of the data that's going to be presented today comes from DPA's data. And I want to be upfront with some limitations and some strengths of that data. Limitations, first of all, we are the public defender, which means no private attorney or pro se cases are represented in our data. All clients have been found to be indigent. So I'll say upfront, this is not a cross section of everyone that's in the criminal justice system. Not everyone who comes before a court is indigent, but only indigent clients, the only clients we have data on are indigent. So you may say, well, why do we even care about DPA's data? Why not just look at AOC and broader? Well, there's a few reasons. There are some strengths of DPA system. Number one, we have a unified statewide system with systematic data entry. We have consistent training across the state. And so while others within the system have their own strengths when it comes to data entry, I believe we're probably the most consistent data enter. If you look at statistics from county to county, clerk's office to clerk's office, you often will find some differences. Also, we're not a bid player in the system. We represent about 75% of circuit court defendants across the state, about 50% of non-traffic defendants in district court. So we are involved in a lot of cases. So our data pool is not small. It's very representative, I think, overall. And also we have a flexible and accessible modern case information system. Last thing I'm going to do today is say, you have any questions? Is there any other information you want? And with our data system, just about any statistical question, if it's within our system, we can get you an answer within, if I have the right tools, within minutes, but certainly realistically within a day or two. So that's just some setup. Not all the stats come from us, but those that do have these limitations and strengths. Like many organizations, a few weeks ago, we issued a statement relating to the aftermath, the death of George Floyd and the aftermath of that and what we felt that stood for in society. This statement's available. I can send it to any of you. But I want to highlight kind of the perspective that we brought to many organizations did a statement in favor of the Black Lives Matter, either the movement or at least the statement. We wanted to come from the perspective of what we see every day in courtrooms from our perspective as public defenders. And that is that at every step of the system, from when somebody thinks maybe a crime was committed, all the way to the execution of that sentence through a prison or probation or perhaps literal execution, at every step in that process, race plays a role. And quite frankly, there's no part of the process in which race for a Black defendant plays a positive role. It's always going to be a negative role for Black defendants or Black suspects within the system. So these were just the categories that we mentioned, that Blacks are more often to be suspected, whereas I may never even be thought to have committed a crime. If I'm walking down the street, a Black man or woman may be approached and stopped, where others are just allowed to go on. Searched when others are just questioned, whereas a Black suspect may be asked to empty his pockets or show his hands, those kind of things. Charged when others are given a warning. Arrested when others are cited and released, and on down through every step of the process to the saddest of cases that Blacks who are engaged in interactions with law enforcement statistically are more likely to be killed in that interaction when others live. Fortunately, that's not statistically a vast number, but the inequity in that is present. So all the way from the beginning to the end, race plays a role. So much of what I'm going to talk about today are talking about data in the inequities with Black defendants before the court. So let's start with some baselines. Here's one, and you're going to see a version of this chart, I don't know, 25 times today. And so for simplicity purposes, most of the charts I'm going to do are going to be pie charts like this. And when you're talking about race, it gets complicated really quickly. We tend to think in terms of white and Black, but if you're talking about racial categories, beyond that, it gets difficult because some groups treat Hispanic as a race, others as a category within races. So I've tried to make it simple. All these charts are going to be simply basically Black and everybody else, just for simplicity purposes. So the Kentucky population statewide, based on census data, is 8.5%. Beyond that, the Kentucky population, excluding Jefferson County, is 6.1%. Now, the reason this is important, and I should have said this already perhaps, the Department of Public Advocacy is the public defender for our agencies responsible for the entire state, but cases within Jefferson County are handled by the Louisville Jefferson Metro Public Defender's Office, which contracts with DPA, so it's a different data system. So our data system, which for all its strengths, covers 119 counties, doesn't cover Jefferson County. So the data, the percentages that I show you today are for public defender cases that don't include Jefferson County. So it's important to think the baseline for the amount, the percentage of Black individuals within the population is 6.1 when it comes to DPA cases, because that's the population percentage in the counties that DPA serves. So just looking basically at DPA clients, if you take every case we've got from DUI and driving on suspended all the way to capital murder, all of our clients together, we have 14.7%. So just already you can see it's over double the percentage of Blacks in the general population. If we look in Fayette County, Fayette County population overall, 15.6% according to the most recent census data that I could find. And one of the, as I mentioned, one of the limitations of DPA data is that it's just indigent clients. So I wanted to look, what is the Fayette County population below the poverty line? Because it would be a legitimate point to make to say, well, DPA data, of course, is going to be slanted towards African Americans because all the clients are indigent, and statistically, the percent of Blacks that are indigent are higher. So that would practically everything I'm going to say could be undercut by that. So we need this as a baseline, that in Fayette County, 21.8% of those who are below the poverty line are Black. So what's the percent of DPA clients in Fayette County that are Black? Well, that goes up to 38.5%. So again, just as with the overall population, the poor population in Fayette County is much smaller percentage Black than DPA clients are. So the much higher percentage of Black clients in the criminal justice system appointed to public defenders than there are in the county at large. So now I'm going to start talking about charging decisions. This is one of those phases of the system in which human beings are making decisions. And when it comes to what someone will be charged with, there's a lot of discretion in that, because a lot of times an act in the real world, a real act, somebody did something, could be charged under many different charges. So I wanted to look at a few of those and what the data shows the racial impact on those decisions are. So the first one, let's say that somebody I use the word infringing, intrudes upon somebody else's property with the intent to commit a crime. Well, in Kentucky, there are 3 levels of burglary. Burglary is entering or remaining in a place that you have no right to be with the intent to commit a crime. There are 3 levels. Class D, and for all of this, I assume everybody here, but maybe not everybody watching knows, Class D in Kentucky is the least serious felony. As you get closer to A, it gets more serious. So burglary in the 3rd degree is a Class D felony. And the data would show, and this is all Fayette County numbers, that 29% of those who are charged with burglary 3rd, a Class D felony, are Black. Burglary 3rd, just as a definition, that's essentially breaking into a non-residence, a store or a warehouse or something like that. Burglary 2nd, which goes up to a Class C felony, a 5 to 10 year sentence, that's a residential burglary. And now the percentage of African Americans charged with that crime now exceed our baseline. Remember, our baseline is 38.5% of DPA clients are African American in Fayette County. So now more than that are charged with burglary in the 2nd degree. If we go up to burglary in the 1st degree, well, let me stop. Definitionally, burglary 2nd is breaking into a house. That's a residence. Burglary 1st is you're committing a burglary 3rd or burglary 2nd, but in the process, you either have a weapon or someone's hurt. Essentially, I'm simplifying, but that's essentially what it is. And for that, the sentence is 10 to 20 years of Class B felony. Those charged with burglary 1st in Fayette County, 60% of all the burglary cases that DPA has been appointed to in Fayette County are the defendant is African American. Let's look at stealing. In stealing, you've got theft, which is simply the theft, the stealing, which if the value is enough can be a Class D felony. So my statistics are showing the Class D version of theft here. There's a Class C version, which is stealing with force, and then a Class B version, which is stealing with force, again, with a weapon or causing injury. And so looking at these, the Class D version, 29.9% are African American. Robbery 2nd, 52% as it goes to Class C. And among all the robbery 1sts in Fayette County, 65% are Black or African American. So again, as the crime gets more serious, and this is going to be the ongoing theme, the percent of African Americans are much higher. So as charging decisions are made, Blacks tend to be charged with more serious offenses. Marijuana charges, possession of marijuana, 48.7, again, a lot higher. Now, there's a lot of people that smoke marijuana these days. But among those that are charged with possession of marijuana for the last year, that's the date range here. This is fiscal year 20 for most of these categories, July of 19 to June of 20. Possession of marijuana was 48.7%. But what about trafficking? Trafficking is a more serious offense. In trafficking marijuana, 58.9% are Black or African Americans. What this shows is either our Black neighbors are selling to our white neighbors, or when it comes to whites, we're prosecuting for possession, and when it comes to Blacks, we're prosecuting for trafficking. Now, for those who don't know the criminal code, let me explain something. Trafficking in Kentucky does not require an actual sale. That may come as a surprise to some, but it doesn't. Trafficking includes within the definition possession with intent to sell, and that gets into a decision by a human being. When someone is arrested and has a quantity of drugs, and my next slide deals with non-marijuana drugs, same thing will apply there. There's a decision to make. Is this quantity of drugs for their personal use, or is this because they intend to sell to somebody else? And that is not clear in most cases, because while packaging comes into play and quantity comes into play, anybody that's gone to Sam's Club or Costco knows you can buy a large quantity, and it looks that way in the store, but it also looks that way when you walk out of the building because you've got this quantity. So the same quantity could be a purchaser as could be a seller, and the packaging could be very similar if it was shortly after the sale. So there's a decision to be made, which one will I charge with? And for African Americans are overrepresented in all marijuana charges, but significantly charged with trafficking more often than they're charged with possession. Same thing, spoiler alert, same thing for non-marijuana drugs. For possession of controlled substances, and this would be first degree, that's heroin, LSD, crack, powder cocaine, methamphetamine, all of those are possession of controlled substances in the first degree. 25% of those charged in Fayette County with possession of controlled substances first degree were African American. But go up to trafficking, the more serious offense, saying we're going to prosecute this as a Class C felony, sometimes Class B under some circumstances, then you're almost to half. 46% of those charged with trafficking are African American. And again, and I said it flippantly before, but I think it's worth thinking about. One of the few logical explanations of this is that Black clients are selling to white clients. Well, I'll say in my experience now this year, 26 years in public defense, that's, I think, not the explanation for this. I think it's not that the African Americans are going into the white neighborhoods and selling them the drugs. I think it's more likely that African Americans who are arrested are being charged with trafficking, whereas whites who are arrested are being charged with possession, statistically more often. None of this is 100%, but the numbers do say something, and that's my interpretation of what they're saying. Let's talk about endangering others. There are two versions of the wanton endangerment statute in Kentucky. This comes to a charging decision as well. Somebody took an action and somebody else was put into danger. And the police, or by private complaint, a charge is filed. There's a wanton endangerment second degree, which is a misdemeanor, or wanton endangerment first degree. Somebody's got to make a decision who's going to be charged. Well, in the misdemeanor version, it's about at the baseline. 38% of clients who are charged with wanton endangerment misdemeanor are Black. Step up to the felony version, all of a sudden 65%. And this goes to how dangerous did we interpret the situation? And I think that goes to the heart of what this whole issue is. And this is the broader issue in general with racism, is we tend to fear that with which we are not familiar. And I believe in interpreting the danger of a situation, I don't believe that what a white defendant did was necessarily less dangerous than what an African American did. But in interpreting the situation, it is easy to believe in the moment that was more dangerous because I'm not familiar with that, or I don't really trust that person. Whereas this person I'm more comfortable with, and therefore I think they're not really, it wasn't quite as dangerous a situation. These two stats, there's no logical reason why these would be different. Some of the others, burglary, robbery, you've got a gun is a factor there that may lead to a more serious charge. And so maybe there's a factual basis that more African Americans are carrying guns at the time that they commit crimes. That may be true. I'd leave it to others to decide whether that's factually true. But here, the level of endangerment, unless you believe that Blacks in society are generally just more dangerous than whites in society, there's no statistic, there's no factual basis why this should be different. So I think this tells a story that whites, 62% of whites are charged with a misdemeanor. 65% of African Americans are charged with a felony in an endangerment situation. Strangulation was a new crime committed created last year to supposedly fill a gap. That's not the purpose of this, to discuss strangulation. I think it was an unnecessary crime that was created when it didn't need to be. I think the situations were adequately covered by other laws, but it was created. So let's see the impact it's had on race in the criminal justice system. So among those charged with second degree, which is a Class D felony, 58% of those have been African Americans. So blacks are overly represented in that second degree. If you step it up to Class C felony first degree, it's 64%. Now, many of the cases that led to strangulation charges had previously been prosecuted as misdemeanors under the assault force statute. So what we've seen with strangulation is a lot of these are worked out in district court, where they're charged with strangulation, charged with a felony, but then they're worked out in district court to assault fourth or attempted strangulation or things like that. So another place to look to see how the impact that race is having on this is to look at the cases that did wind up going to circuit court. Among those charged with strangulation, how many of them wound up going to circuit court, and what were the percentages? Well, among those that were seen as worthy of being prosecuted to the fullest extent as a felony, was 72% were Black or African American. So almost double the representation of DPA clients in Fayette County, and way more than double the actual population of African Americans in Fayette County. Now, beyond charging decisions, there's statistically significant numbers in the racial breakdown of charges relating to interactions with law enforcement. So I've picked out 3 of them here. Resisting arrest, which is just what it says, that a law enforcement went to arrest someone and they resisted physically that arrest. That's a misdemeanor. Tampering with physical evidence usually means that as police were approaching, the person did something with the evidence at that point, threw it out a window, flushed it down the toilet, something. Assault third is an actual assault on a police officer, which most often, doesn't always, but most often happens in the arrest process. So these are 3 things that are related to the arrest. And you'll see with all 3 of these, almost the same percentages, but over half of the people in Fayette County represented by DPA who are charged with resisting arrest, tampering with physical evidence, or assault third are African American. Now, this is an undercurrent of all of this is how much of this is based in fact as opposed to discretionary decisions by human beings. I mean, if it is true that African Americans are more likely to assault police officers or resist arrest than whites, then absolutely these numbers are exactly where they should be. But I think the other story related to this slide is, what can we do about that? If that's true, number one, it may not be true. It may be that officers are more offended or more upset about, respond more negatively to resistance from African Americans and end up filing charges. Could be that. But even if it's based in fact that this is legitimate charges against legitimate resisting situations, this goes to what this group hopefully is going to make recommendations for, and what can we do to improve the relations between law enforcement and the African American community, where these types of violent incidents are minimized on both sides, to the extent this is based in fact. But the fact that in a county that is overwhelmingly white, over half of these charges are filed against Blacks says something. And the other thing, in the worst case scenario, when suspects are killed by law enforcement, this is, and I cite DPA here, we don't keep statistics on this. This is a bad site. This came from, I think it's mappingviolence.org, a group that tracks police law enforcement killings across the country. Fortunately, this is statewide numbers, because fortunately Fayette County has had very small sample size, and that's a good thing within this time frame. So I went to statewide, and the number was 15.6%, so about double the population in these worst incidents where a suspect ended up being killed by law enforcement. So those are the interactions. Now let's talk about the effect of prior convictions on the charges. As this rolls along and more African Americans end up in the criminal justice system and convicted of offenses, then some crimes are crimes just because of those convictions. So when you look at possession of gun by a convicted felon, 74% of the people that are charged with that offense in Fayette County, represented by DPA, are Black or African American. PFOs, those are those are repeat offender statutes. It's not a crime itself, but if you're convicted of another felony, this generally will raise those sentences. More than representative numbers of Blacks and African Americans are charged with those as well. Over half of those charged with PFO second are Black or African American. Let's look at the incarcerated. So if you got all these people in the criminal justice system that are overly, where Blacks are overly represented, makes sense that the incarcerated population would wind up there. So I've got three numbers. The general population, again, as a reminder, 8.5%. Prison population in Kentucky is 21.8% as of 2 weeks ago. And the juvenile detention is actually just over half. That's a much lower number. There were, as of the report that the information that I have, which was in July, there were only 105 juveniles in detention, so much lower number, but over half of those are Black. And so now seeing that over half of the juvenile population in a state that is over 90% white, or over 90% non-Black at least, what's going on in the juvenile system? Well, that turns out to be kind of where the worst parts are statistically. So this is a different kind of slide. It's a busier slide, I understand that. But this is looking at it from a different angle. And that is, if you walked into a juvenile courtroom, which you wouldn't be permitted to do because it's confidential, but let's say you did, and there are two juvenile defendants, that DPA juvenile clients that are in the courtroom. One's white and one's Black. What are the chances that they're charged with certain things? Well, if you go down the list for the white defendant, they're most likely charged with a Class A misdemeanor. That's actually true as well for the Black defendant. But the second most likely thing that a white juvenile client is charged with is a status offense. Status offenses are runaway, missing school, truancy, being beyond the control of your parents. They're things that aren't crimes if an adult does it, but they're crimes because they're a kid. And so, like, I don't have to obey my parents at this stage of my life, but when I was 16, I did. And so that's what a status offense is. If you go over on for the Black defendant, they're much less likely to be charged with the status offense, but they're much more likely to be charged with more serious offenses. So let me take out the ones that are similar here. A misdemeanor, B misdemeanor, contempt and violations, very similar. But look at these differences. The chance that juvenile's charged with a Class D felony, slightly higher for the Black child as opposed to the white child. Class C felony, it's almost double the rate. An 11% chance that the Black client's charged with a Class C felony, just a 6% chance for the white client. And when you get to Class B, that's the big deal. Class B, for a white client, 2%, 1 out of 50 or so, is going to be charged with a Class B felony. But more than 3.5 times as likely is the Black client to be charged with a Class B felony. Now, there's a couple things to that. So number one, a Class B felony, if they're tried as an adult, is 10 to 20 years, so the years matter. But what's more important in the juvenile context is that makes the Black client eligible for transfer regardless of their prior record. If it's a B felony, it's transferable. And so if you want to try a child as an adult, one way to accomplish that is to charge them with a more serious offense. Again, not that the facts don't merit that, but there are discretionary decisions here as to what to pursue and what not to pursue. And pursuing a Class B felony allows for trial as an adult. And so looking overall, Juvenile clients overall that DPA represents that are charged with Class B, A, or capital offense, 81% of those are Black. Juvenile clients transferred to circuit court to be tried as an adult statewide in fiscal year 20. This is true statewide because these numbers also include Jefferson County. 64% were Black. And the number in Fayette County, the percentage of Black African-American, the percentage of those transferred to circuit court in Fayette County for fiscal year 20 was 100%. Every child that was transferred to be tried as an adult in the last year was Black. There are 8 of those. If you would anticipate what the number is, it's not 1, it's not 2, it's 8, and all 8 were Black. Last thing I want to say is the recommendations, it goes, I think, beyond the jurisdiction of this group, but criminal justice reform is a common topic for task force and committees and things people want to accomplish. And I've never talked about this anywhere, but I thought it was appropriate to talk about it today. The racial impact that criminal justice reform has, which may be not what you think it has. And so this is a point I'm going to be raising as criminal justice reform discussions happen going forward. And that is that criminal justice reform, as it has occurred in the last 5 years or so, almost always benefits white participants in the criminal justice. So I've got a couple examples of this, but then my experience tells me it's also true elsewhere. But a couple of specific examples. So one thing I decided to do was let's look at the prison population on February 15th, pre-COVID. At that time, Black or African Americans represented 20.9% of the Kentucky prison population. You may remember from a prior slide, in July it was 21.8%. Well, what's happened in the last 4 months? What's happened is the governor, through executive orders, courts, parole board, the prison population in July is about 3,000 people less than it was in February, because with COVID, different people have done different things to reduce the prison population. And I have applauded every one of those. And we have called for more. We believe the prison population could be significantly reduced without an impact to public safety. But what has happened is that when those 3,000 people were identified as to who should get out, the percentage that got out that were white was much higher than the percentage that got out that were Black. So the overall effect is to actually increase the percentage of Blacks in the prison population. Now, that's not to say that Black inmates did not benefit. The numbers I looked at, I think about 700 Black inmates were released. That's great. But percentage-wise, that was a smaller percentage than the overall population. So the population of Blacks within the prison population went up. Here's a second example. In 2014, Kentucky legislature passed Senate Bill 200, which was juvenile court reform. And it made a lot of changes as to who can be transferred and who should be probated and diverted. There makes a lot of positive changes. And in fact, on this slide, if you look, the number of cases, and these are clients, the number of clients within the juvenile system between 14 and 16 was practically cut in half, from almost 6,000 to 3,500. But if you look at the percentages, the percentage of white clients went down and the percentage of Black clients went up, because the reform disparately benefited white participants in the system. And so once the reform was implemented, it actually exacerbated percentage-wise the racial disparity within the system. Now, again, if you look at this, my quick subtraction here, 1,062 to 702, so it looks like 360 African-American clients. It was reduced by 360. That's great. But percentage-wise, almost 2,000 less white participants in the system. So that's a point I've never made before I was preparing for this, but that's, as criminal justice reform is considered, reform needs to go to the types of charges and the types of situations that where Blacks are overly represented within the system. And that's not possession of drugs, it's trafficking of drugs. Keeping in mind that a lot of trafficking is not sale, it's possession with intent. That's how reform that improves the racial breakdown of the system that's what it would look like. You'd recognize the discriminatory impact going in the prison, and we would counteract that with similar measures coming out of the prison. So that's the end of my prepared presentation. I would welcome any questions at this time.
Thank you, Mr. Preston. Before we open up with questions, I assume that you and Mr. West are going to field questions, comments, or Mr. West, do you have something that you need to add now?
No, I don't have anything to add. Thank you.
Thank you. Okay. I think we'll just do it like this. Very informative. Thank you. Those that have had some conversation about this even prior to this, and those of us that have interest, I'll open it up to the subcommittee for questions before I add anything that I've been observing and thinking. So just, Brother Harris, I see you.
I do have a question. In terms of percentages, did you do any study or keep any data showing how many cases go from state court, go over to federal court, where the penalties are much higher?
You know, Mr. Harris, that's a great question. The answer is no, I didn't do anything with that. DPA does not handle anything in federal court. And so I don't have access to that data within our system. But I would not be surprised at all, particularly when it comes to trafficking and guns. Those are two areas that are frequently transferred from state to federal court. So I would not be surprised that the statistics backed up the disparity there, but I don't have those.
Let me ask you, Brother Harris, a follow-up on that. And I'll say this for everyone as we craft our questions and or comments. Please, let's keep in mind that we are swiftly shifting to we craft recommendations. And so if we start kind of with that in mind, I think that'll be helpful for us. Let me ask you, Brother Harris, tell me more about that question and how it might impact us or work.
I was just wondering because I do know that oftentimes these cases, well, I guess someone's looking at a maybe a 3-year sentence in state court, and then they go to federal court and they're looking at a 5 to 10-year sentence. And I was just wondering if there was data that shows the percentages of white participants that get transferred as opposed to African-American participants. And again, those are decisions that either the prosecution is making or the police is making because they're contacting the federal prosecutors to request that they take a case. And I know sometimes the federal may request that they get a case because they're working jointly. But the ones that I get, usually they are, you know, at least I'm told that the either the prosecutor or the police officer contact the federal agency to see if they're willing to take the case.
Thank you for that further explanation on that. Brother Scarsoni.
Yeah, Mr. Preston, what about probation and probation revocation? Do you have much data on that?
We don't track in a reliable way. We try to track revocations, but I wouldn't deem our data reliable on that. So no, I don't have that. What do you suspect the data would show?
Well, I don't know, but I mean, that's clearly where the judiciary comes in. A lot of these decisions are police, prosecutor decisions. You know, we can't dismiss cases just like that, you know. But the sentencing, as you know, is a product of the PSI, it's a product of criminal history and all of that. And I'm just curious whether these imbalances also exist at the probation level and the revocation of those probations.
Yeah, that would be a good thing to look at.
Mr. Preston, I have a question. Jennifer Kaufman. I we had a comment before by one of our subcommittee who sent an email either to me or to the entire subcommittee suggesting that your statistics are kept by appearance and not by actual case or by defendant. And I just would like for you to comment on that.
Well, Judge, I appreciate the question. First of all, I would say the statistics today were mostly percentages of race, and so the volume wouldn't really matter. But I appreciate the opportunity to respond to that. Our statistics are not based on appearance. A case is a case. There have been questions about our data for years that I think is not accurate at all. There was a KBA task force in 2009 that looked at our data and prosecutors' data and court data and found them all to be accurate within their systems. We track a number of things, but no, a case is a case, and doesn't matter if there's 50 court appearances or if they pleaded arraignment. It's a case, and to that end, even a capital case is one case for us. Even if it goes on 2 or 3 years down the road, we count it only as a single case when it first comes up. So our data is reliable because my most important thing is allocation of resources within our department, and I can't afford for our data to be anything other than solid.
Well, when you have one case involving 2 defendants, I assume you would count that as 2 cases, right?
Right, because there are two defendants, 2 defense teams. We do. Another thing that's come up, and sometimes this could be related to the appearance, is if a case originates in district court and has a preliminary hearing, goes to the grand jury and is indicted in circuit court, we count the district court case and the circuit court case. And by doing that, we're counting the same way as the court system that counts the F case and the CR case. Prosecutors use the court system data as well with district court criminal and circuit court criminal. So if we counted one case, we'd be counting half the cases of the other parts of the system. So that may be the basis for the appearance thing. But we count a case as a case.
I have a question. Looking at these disparities, what are your recommendations? How do we get rid of these disparities, man?
You know, Mr. Dunn, I wish I had the answer. I'd love for that to be the second half of my presentation to tell you exactly what to recommend. I think the first thing we need to do is have conversations like this, where you look at the data, because it can't be about looking at a prosecutor, looking at an officer, looking at a judge, looking at a defense attorney and saying, don't be racist or apply the law evenly, because we all want to do that. We think we're doing that. But when you look at the data, we're not. These decisions are being made in a certain way for a reason. So I think the first thing is we got to have conversations like this that are open and respectful and polite and not turning into accusations or defensiveness. Beyond that, I think judges, Judge Scorsone is exactly right that there's only so much they can do at charging, but when it comes to overseeing the system, judges have a role to play here to say, is this the right charge? Legally, if a prosecutor goes to the mat, constitutionally, a judge can't really dismiss a case. But I think a judge can play an influential role in saying, this doesn't feel like a felony. This feels like a wanton endangerment second to me. So that's one thing. And I'm not meaning to put the burden on judges. I'm just saying systematically, that's something in the system. Because when I say this looks like a misdemeanor, it just sounds like a plea negotiation. Beyond that, I think there should be some accountability at the law enforcement when it comes to charging decisions. The kinds of statistics that I did today, I think should be done by law enforcement. How many African Americans are being charged with trafficking? How many whites are being charged with possession? And can we explain the difference? One difference in that specific example is, where does law enforcement use their resources when it comes to informants? I've represented plenty of clients that either turned informant or were bought in or were charged after a controlled buy using an undercover officer or an informant. And the choice of where do I send that informant, that is a choice that's made by a human being that has a racial impact. If I send them into the part of town where I know the person they're going to buy from is African American, but I don't send them to the white community where I know they're using heroin. I've arrested, a dozen people in the last week, or stopped, or there have been overdoses in this area of white neighborhood with heroin, and I don't send informants there because I'm sending them to the part of town where African Americans are. Those are the kind of decisions that affect this, and I think increased accountability, which can be done through the data collection law enforcement level.
But when we look
Thank
at it,
you.
I don't think minimum mandatories, of course, it definitely hurt the Black community. So I wouldn't want to say we need to do that, but it seems like we're looking at systematic, and structural racism. Those discretionary clauses and the discretion is what's killing us as a people. So what can be done to make a recommendation to get rid of discretion without, of course, if we did get rid of the discretion and we put a clause in there as a minimal mandatory, or we know it's going to kill us even more. So is there anything that can be done to get rid of those discretions? Because I may be biased because I'm Black, but I know these facts, and I know what all these charts are real based on the way that I grew up and the people that I grew up with. Now you show it, now everybody else sees it. But if there's still discretion, and we know that these are facts and they're still not going to change, a conversation is going to help it, man, because we've been having this conversation for over 60 years. So is anybody else out there knowing what we can do other than just saying we having conversations? Because like you said, the judges do have discretion, but I can't put a percentage on it, but we know they're going to rock with the prosecutors' recommendations, even if they, for most part, know that those recommendations and those times that they're giving out are way too high. You see somebody that's been fighting a case for 2 years, and then that individual did a complete complete turnaround. He's working, he's doing everything good, but 2 years ago, he got caught up with a case. You're gonna say, okay, man, you did this crime, you was trafficking, but we're still gonna give you 10 years, even though you have shown that you can change. So is there anything that we can do to get rid of those discretionary sentencing, or put more pressure on judges and the prosecutors to try to help do away with these disparities?
I think you're always going to have discretion in the system because you're dealing with human beings. But I think some of the changes that might help the kinds of things you're looking at, I think we've got way too many things that are felonies. I think we should narrow many felony classifications. Many felony, one endangerment is way overbroad. So that's one crime that could be limited. So that's a criminal justice reform that I think would benefit across races, is to severely limit the number of felonies and the effect of a felony conviction. The expungement that's been available for the past few years, I believe, has been a very positive step. But I think limiting PFO to where the impact of a felony conviction, if someone reoffends, that it doesn't create a mandatory minimum of 5 years or 10 years, I think that could help. But as far as the discretion, you're dealing with humans, so I think we have to deal with educating and holding accountable human beings.
So we are going to move it beyond conversation, and we are going to use our energy and our expertise and this opportunity to move it beyond conversation to address those obviously empirically proven disparities. I see Judge Isaac, and then Sister Queen, and then Sister Price, and then I want us to, the balance of the time, the last 30 minutes, I'm going to hand over to Judge Kaufman to move us in our agenda. But let's go in this order: Sister Isaac, Sister Queen, and then Sister Price.
Okay. Mr. Preston, thank you for educating us here today. And I think you maybe addressed this question after Mr. Dunn asked it, but in your opinion, with the bias in charging decisions, what percent, I mean, ultimately the county or Commonwealth attorney decides what the charge is, but do you see that there's an overcharging going on that's racially biased at the beginning, and then it may be more difficult for the Commonwealth or county to tell their officer that no, they're not going to charge that? Where do you see the percentages on what's happening?
Yeah, it's hard to say percentages. But I mean, overcharging is a problem throughout the system. I think there's an incentive for prosecutors to charge as many crimes as possible. I think our criminal justice, our penal code has a lot of overlapping crimes. And so there can be legitimate stacking of charges based upon a single act or a narrow set of circumstances. And so that can have a racial aspect. I don't have statistics on that as to whether charges are stacked against African Americans more than they would be against other defendants. But that can be an issue. But I think the other thing that you point out that's important here is the dynamic between prosecutors and law enforcement. I have seen conversations that in a district court when we're trying to work out a felony to a misdemeanor. I've seen law enforcement officers get upset with prosecutors who want to work something out and say things like, well, why am I even out here? And use their public safety role as kind of a sword to say, you know, why am I even spending my time on this case if you're just going to work it out? So there's a systemic pressure once the wheels are turning to keep the wheels turning. And that's why I think it's important to realize the bias that exists systemically at every step of the process. So once an African-American person's in the system, the bias is already at play. And so then if there's pressure not to dismiss or reduce, if there's pressure not to probate eventually later on, that's already in play. And the African Americans are already overrepresented in the system when we get there. So I think to your point, I don't know a percentage of times that this comes into play, but once the charges are filed, I think there's pressure at every level to maintain those charges. And if they were overcharged to start with or charged when it shouldn't have even been charged, then the systemic pressures come in on, well, I'm not going to dismiss it because I want to back up my officer, or the Commonwealth attorney backs up the county attorney, or the judge backs up the Commonwealth attorney. There's that pressure that it would take someone to kind of plant their feet firmly on the ground and say, by golly, I'm not going along with this. And that's just hard to do by all of us.
Thanks. Thank you.
Okay, Mr. Cozart, right? Okay.
Yes,
Thank you, Mr. Preston, Mr. West, for being here today, and hello. And
Ms. Queen, excuse me
yes.
just a minute. I just want to confirm one thing I've been asked to confirm. Galaxy Note 9, Denotra Gunther, is that you?
I believe I saw her earlier on that line.
I haven't, she has written a note on here, but I
That's me, Judge. I'm sorry. I'm in the car.
thought so. And Laura Hatfield thought she saw you, but we just want to be sure. Okay, I apologize for the interruption, Ms. Queen. Please go ahead.
Okay, thank you. I guess my question a little bit, I was hoping that Assistant Chief Maynard would maybe jump in on this and provide perspective, as well as maybe the judges and also Mr. Preston, Mr. West, but just for conversation and talking about this charging up, the charging decisions. And I do believe that's a pretty critically important aspect of how systemic racism pieces sort of, the origin of where we start. And where the ball begins to roll, and how it kind of picks up steam over time. And, and I wanted to know, like, as we see original, initial charges being done, then additional charges that are all part of that initial citation, right? That is where the law enforcement officer goes to a situation, circumstance, traffic stop, whatever it might be. And then, from there, makes a decision at that point about what is there that is, from their perspective, as a legitimate charge. And my question, I guess, first to Assistant Chief Maynard is about, can you talk about the training? Can you talk about this perspective of the field training officer about, how do officers make those decisions based upon charging something that is initially, perhaps at one level and then adding other subsequent charges? Where does that training piece, come into the equation? If you could address that.
Yeah, no, Diane, that's a great question. Part of it, some of the crimes that Mr. Preston brought up are defined by KRS.
Chief?
Yes.
Hey, Chief Maynard, your sound is not like the quality it usually is. I don't know if there's something different you've done. It's almost as if there's some, different atmosphere.
Yeah.
Is that better?
Yes.
Yes.
It is.
So great question, Diana. And part of the charges that Mr. Preston covered are clearly defined in KRS. The burglaries that he talked about, you're talking about a store that gets broken into, you're talking about a residence. And then you go on and you talk about, whether a weapon was used. That's clearly defined. And so those charges are part of the learning process for the training phase. And the other thing is there's victims associated with those crimes. So to say that those are upcharged or that they're not is a little difficult to process from my end. It's been a while since I've charged somebody, but there's a KRS that says this is what this charge is, and here's how the victim felt or victim perceived, and then we place that charge. Is there some discretion there? That probably is more along some of the narcotic stuff, some of those things that Mr. Preston discussed. But a lot of that is part of that field training phase. The traffic stops may be a little bit more that you had mentioned, where say someone gets stopped for speeding. Well, you have a clear speed limit, the individual stopped, and then part of that traffic stop is you ask for registration, you ask for driver's license, and you ask for insurance, which all those are KRS violations that are clearly defined in our statute and our laws. And so if you don't happen to have those, or you don't have your seatbelt on, then yes, additional items can come on that citation as part of that. And again, there has to be a factor that goes into that of the officer discretion is, well, did you have your seatbelt on? Yes or no? Did you have insurance? Yes or no? Were you compliant, immediately pulled over? Yes or no? Were you speeding? Yes or no? So the officer does have discretion whether they want to write the one for just speeding or if they want to write all of them, which by law says that they can.
If I can follow up just with that a little more about evaluation, about how officers are evaluated about performance, about such things, how does these charging decisions and this discretion that they have, how is that part of, understand, I don't know how the police department exactly evaluates an officer's performance, based upon, let's say that I went to a scene or I went, traffic stop, whatever it might be, and I should have charged 2 or 3 other more things and I didn't do it. And I decided that I only needed one, I didn't need to charge, tampering, or I didn't need to add something else to that. How does that get evaluated? Is there how's that evaluated in regard to charging more charges versus, perhaps not charging enough? I mean, how's that done?
I think the biggest part of it is that we don't make more money with more charges. That's everybody. Well, by the 15th of the month, everybody has to have a quota. We don't have quotas. That's a huge thing that the public thinks that we have quotas we have to get to. So I don't care if you write 1 ticket or 15 tickets. If you feel that you're out and part of you working, if you're on a traffic grant and you're assigned to stop speeders, 1 citation works with the 1 speeding complaint. It's the officer's discretion. Now, what I will say, the supervisor will have a conversation and the field training officer have a conversation. If I stopped you yesterday for running a stop sign, and we're having the same neighborhood complaint, and you're running the stop sign for the second day in a row, you may or may not get the ticket. I would think yesterday we had the conversation, hey, we're out here for this reason, and you run through the stop sign the second day, you're probably going to get another ticket. If you're driving or if you have a brake light out or the tags are expired and right now we pull you over, I expect my officers to understand there's probably a little bit of limitation with some COVID going on that they may not be able to get their tags caught up. There was a point 3 months where there was a window there. So there should be some grace given. So those conversations happen. The supervisor level should be having those, and beat officers, the field training officers, that all kind of goes into play.
So if I could respond just real quickly to one thing the chief said, and Chief, I appreciate your comments. There is some discretion. I mean, if we talk about burglary first, it's easy to read the KRS and you're picturing, okay, somebody's home and somebody breaks in with a gun, that's burglary first. Let me tell you about some burglary firsts that we're facing right now. And these are actual cases DPA is currently defending. Shoplifter from Walmart goes in and gets less than $50 worth of stuff. They've previously been banned from Walmart. They're caught shoplifting and they shove a loss prevention officer on the way out the door. That's currently charged as a burglary first because they were banned from Walmart. Therefore, they're going in without a right to be there, with the intent to commit a crime, which was low-level shoplifting, and they hurt someone out on the way out if they shove them down. That's currently charged as a burglary first. That is a discretionary decision. So another defendant, and I don't know if the Lexington Police Department is taking that theory on burglary, but there are law enforcement that are doing that right now. There is a discretion. Am I going to charge this person with misdemeanor shoplifting? Am I going to charge them with assault? Or am I going to go all the way up to the Class B felony of burglary first? You know, there are some cases that are cut and dried based on the KRS reading, and there are other cases where we bend the KRS to fit the circumstance because we really want to put this guy in prison. Those are the discretionary decisions that can have an impact in this area.
I agree, and even to the pushing the theft subject down. One, he's been banned, so he's been charged with a prior theft. He's criminal trespassing already, just immediately being on the property, committing the second violation of an additional theft, and then pushing the guy down, pushing the loss prevention folks down. Technically, that could be a robbery as well. I mean, it covers both bases. Working with some of the county attorney's office, our officers have looked towards trying to do the burglary third or burglary first, like you stated, for that instead of the criminal trespass third, because it's multiple offense that's going on at that point.
And I have something to add. You know, discretion is basically legal discrimination because you have the discretion to treat somebody different than you treat somebody else, which is why we have to have things in writing that says that we cannot that's why discretion kills us as Black people. You know, when we look at systemic structure, it's embedded in the structure that it's killing Black people discretion. So if you have the discretion to run a tag, or there's a discretion to pull somebody over, discretion not to charge, looking at the charts, the discretion is always to charge the Black people. We're being charged with more based on the discretion of the prosecutor not to drop the charges, based on the discretion of the judge not to question the prosecutor, based on the discretion of the police officer to charge us more heavily. So every step of the way, like Mr. Preston said, as soon as a Black person gets in the justice system, there's always pressure to charge us heavier. So the discretion that officer stops, prosecutors, judges, their discretion is what's killing us. So if we are here to eliminate the structural racism, the discrimination, we have to get rid of a lot of these discretionary clauses and make things black and white and actually ink it into law and policies and procedures to protect those of us that are vulnerable to the discretion of others that are not doing it in a just way. And not saying that all cops are the same way, but those discretion is killing us.
It's the task of the group to do that, there is no question of the data that we've been presented 2 times now in rapid succession. I know that that there are other angles that we will be entertaining as well, because we have those that are in the Commonwealth attorneys and in the county attorneys. But we have been shown that quantitatively that the disparities exist. Sister Queen, am I okay to transfer it over to Sister Price, and then we're going to jump to Sister Kaufman? Are you good?
I'm just fast comment is that because the charging issue, I think, is such a decisions are so incredibly important because it also affects the bonds and the this has impact about how high these bonds are for persons who go before the judges and when judges set bonds. And and if we're not accurate, I would only add, I think it's important to explore all that very carefully, because if that isn't really on point like it should be, we really are causing people a lot of this is really having a lot of impact on people's lives, especially through the bonds that are set in regard to it too. So thank you, Mr. Kozak. That's all for me.
A lot of impact, a lot of oftentimes negative impact, oftentimes disparate impact. Dr. Price.
I have a series of questions, Mr. Preston, and one of them may be something you may have to respond to later. But the first question was motivated out of something Chief Maynard said about the victims and how these crimes often involve victims. So one of the things that we have known from data in the criminal justice system is that the race of the victim can also lead to less charging, less severity in crime, and also punishment. And I was wondering if within your data, you're able actually to give us any information around how these statistics might look in crimes where there are identified victims and the race of those victims. And if we see similar discrepancies in that data, for instance, where robberies where the victim is African-American, there might be lesser charges and lesser sentences for those people if convicted. My other question is, we've had multiple questions about diversionary programs and the low numbers of participation of African-Americans in those programs in percentage-wise. Could you talk about the role of your office and how those decisions are made? And then the last question is a broader question, which is, so we're asked to engage with systemic questions, and although your office may be adversarial to some of the experience and the people who have spoken to us before, you still live in a society where there is a widespread bias. So could you talk to us about the task that your office has taken or the efforts you have made to deal with the potential bias among the people who work in your office so that they could be more fully advocates for the people that they represent, given the large representations? There's no reason to believe that because you work on the defense side, you are not susceptible to other concerns about bias and fear and perception. And so could you talk about that as well?
There's a lot there, Dr. Price, but I'll do my best to get through it. On the first one, unfortunately, I've got a short answer on the race of the victim. We've got a place in our data system to track that information, but that's a voluntary entry, so data would not be reliable there. We do track it as a mandatory function in capital cases because we're aware of those studies that show the impact that on the ultimate decision. The race of the victim, I believe in the capital context, actually is more correlated with the outcome of a case than the race of the defendant. So we're aware of that. I don't have any additional data on the race of the victim in like burglary cases and robbery cases. On the diversion programs and things, the role of our office as public defenders, we are representing individual clients. And so our attorneys are trying to get diversion, deferred prosecution, any type of non-conviction outcome whenever possible. And so we're advocating for individual clients. And if we see that, I know that in at least one county, and at the moment, I don't remember which county it was, I don't believe it was Fayette County, We had a diversion program that had never had an African-American approved. The prosecutor and judge had never, came on recommendation of the prosecutor, but the judge also had never approved someone, an African-American, to be in this program. And we had a client that technically didn't meet the criteria, but the attorney went to bat for the client on this basis and said, look, this, not accusing anyone of anything, but this just can't be right that we have a system in 2020 that's 100% white in the criminal justice system. And that client,
implicit bias,
because of those arguments, was able to get that client into the diversion program there. So we advocate for specific clients to try to get that. To the extent we wear a hat as a player within the system, we try to make sure that things are set up so that there is no racial bias within the application of those programs. But our biggest role is we advocate for all of our clients individually to try to accomplish that. Finally, I really appreciate the question on what we've done within DPA. And your question actually makes me think that I regret and apologize that I have not already acknowledged in this. I don't want to be somebody representing an agency that just wants to point at law enforcement and point at prosecutors and point at judges and say, y'all fix yourselves. You're absolutely right. There's bias within our own ranks as well, both implicit and unfortunately sometimes explicit. So what we've tried to do, we just had an annual conference where we had a number of dedicated sessions, both to implicit bias, but also the history of systemic racism within the criminal justice system, some of the roots, historical roots that are still at play today, some of the things that come into play that lead to these disparate outcomes. We've tried to train staff. We've done implicit bias training for all of our leaders. In the near future, we're going to, we have in September scheduled another training for our leaders on racial impacts of the criminal justice system and our own role in that. I can say as my own, as someone's been doing this for quite a while, I've had cases, I'd like to say I don't view things through a racial lens when I have clients, but I'll say I've had clients where when I'm assigned their case, I've never met them before, I get their criminal record and I see that thing that's 10 pages long and my own mind goes to a certain place like, okay, now I know what I'm dealing with, lifelong criminal, all that. But now I realize, 10-page records, there's a racial aspect to that when it comes to the disparate interactions with law enforcement and the initial charges that start early in life that can build to this long criminal record that maybe someone who lived in a different part of town may have had the same experiences, but doesn't have a 10-page record now. And so we're trying to educate our staff on that. And to the extent we're battling some things in the current environment where we've got employees who I'll just say don't really believe in the maybe the goal of this task force or other things that are going on in society, and that creates challenges. And we're trying to address that right at the core, because if we're going to represent our clients, we've got to understand the impact of the criminal justice system on Black communities, and we're trying to deal with that.
David, I think you're muted.
Brother Preston and Brother West, we thank you all. I'm going to need to thank you all. I know this committee that ingest and digest, and then we'll have we're moving forward with some recommendations, perhaps some additional questions. I know we'll have some additional comments in reference to your presentation from some of the folks that are on our committee. I do want to do this. I want to kick it to Sister Kaufman to kind of synthesize today and talk about us moving forward,
Sure.
if we could.
I'd be happy to. Mr. Preston and Mr. West, I can't thank you enough for being here. Your perspective is needed. As I said, we recognize early on that we needed your views, and we may be asking you again to come back. We will. I'm quite sure we have some follow-ups. I have one follow-up, and I'm not going to ask it today, but I think it needs to be considered, and that is your caseloads. You mentioned looking at a 10-page record and automatically going to a place mentally in which you think, okay, now I know what to do. That's a shortcut. And that is a shortcut that sometimes people do when they're performing triage. And if you have a huge caseload, you have to do that. I supervise law students and send them into courtrooms, and universally they come back talking about your people's caseloads. So I think that's part of a problem for the system. Well, thank you very much. I'm going to let Mr. Preston and Mr. West leave if you want to.
Yes.
We do want to point in a forward direction.
Thank you very much.
Thank you so much. Before we can point forward, though, I want to point backward just a bit. You know, Dr. Potter was here on Thursday, and we need to talk about what he said within the framework of what recommendations do we want going forward. And he actually brought up several categories. I would like our next meeting, today's Monday, maybe on Thursday, to talk about some of the issues on which Dr. Potter focused. But I want to bring up one right now, and that is the area of police discipline. Ms. Minifield has already made a detailed recommendation, and we spent some time talking about that. Judge Scorsone has offered a comment or perhaps an amendment. I don't know how that actually ended up coming out. And now Ms. Queen has also offered a suggestion along those lines, and it's mostly about citizen involvement. And I should say I have a bias about that word citizen as opposed to civilian, because I'd like to think that our police department is a guardian and not a military approach. And the word civilian to me connotes too much military. But Ms. Minifield, when you talked about Citizen Review Board, you said there have been mixed results with the Citizen Review Board. When Dr. Potter talked last week, he also said some of these have worked, some of them haven't, some have been more successful than others. And then Ms. Queen, in sending out perhaps the email that accompanied her recommendation, said, you know, some of these come to fruition and some don't. And she suggested that maybe there are some national agencies we can talk to. And I think we need to decide how much specificity we need right now. And Councilwoman Masadi, perhaps you can help us with that when we examine this in more detail, how much specificity we need in our recommendations to make them bear fruit. But I think particularly with regard to the Citizens Review Board, we need to decide, do we do something stopgap now, or do we really try to get it right? Or do we have a combination? Do we do what we think is best right now, but suggest a more in-depth study? And so, you know, it's 5:26, so I hesitate to start that discussion right now. But I do want us to talk about that on Thursday. Councilwoman Masadi, you're muted. So maybe you can unmute your microphone, and because I see you have your hand raised.
I just want to follow up on what you said, Judge, as specific as possible, because this will be said too often and it's not specific. There'll be a lot of deliberation, a lot of maybe not understanding what we intended to do. So specific is definitely what we need to do. Go forward with.
Okay, well, that's a short answer to a long question, and I appreciate that. And that lays the foundation for it. Ms. Queen had sent Mr. Cozart and me some articles and some information about people she knows on a national level who can give us some ideas about where Lexington should go. And I suggested, Ms. Minifield, that she get in touch with you, because it was your recommendation that started this whole. So I encourage you, we said in the beginning, we're not going to divide into groups to discuss this and have some kind of team approach, but it's fine for you to talk individually about some of these things. And I believe you should. And some of these people who are national experts are available for phone calls if you want to consult with them. And if you think we need them here, you can say so. But I think we should move toward looking as specifically as we can at everything that we talked about, including everything that Dr. Potter mentioned on Thursday. So take a look at your notes and let's use that as a springboard for discussion on Thursday if we could. Judge Scorsone?
Yeah, thank you. I didn't know this, but there's actually a National Association for Civilian Oversight of Law Enforcement.
Right.
And this publication here that has all the description of these models, it's got strengths and weaknesses for each of the models.
Right.
There's no perfect model for any city. It's a matter of the community trying to come up with the best system for it. So
that is the group that Ms. Queen has been knows some people where she knows some people, and she has been talking with them about their availability. So that's the very group, right, Ms. Queen?
And I can put this publication on the Dropbox if you'd like, because it goes over all the models and so forth.
I think she already sent that to at least to Mr. Cozart and me. Did you put that in? Did you get that to Laura to put in our resources?
I do, as I recall, I did. I put that. I also put the Center for Policing Equity, and I wanted to kind of, I guess, demonstrate that there are several organizations out there that really can help the committee and commission think about this in a full-bodied way, so that whatever decisions it gets put out today don't become the problems tomorrow or down the road where we're trying to fix something else because we just yes, I did.
Yeah. So I think especially Ms. Queen and Ms. Minifield, you two need to talk, and Ms. Queen, you need to make sure Ms. Minifield has those publications you brought up earlier today. I also have a New York Times article from, I think today, that the local public defender office sent me this morning, and Mr. Cozart, I think they sent it to you too, and I'll send that to Laura for putting in our folder. It is 5:30 and we have to stop. We are meeting on Thursday at 3 o'clock. I think in what direction we'll be going now, and we'll get out an agenda as quickly as we can. Thank you to everybody. I'm looking at the chats, and I don't think there's anything else I'm supposed to be doing right now. So I'll see you on Thursday.
Let's remember that our town hall
that's
is
right.
tomorrow. And that invitation, I'm looking, and that invitation Quinn has actually sent out. And so that it's 6:30 tomorrow.
Right.
And so we will be representing this group in Judge Kaufman, Dr. Price, and myself. And so please tune in and give feedback and be represented for that, because this is certainly a collective effort. And so we're just simply representing. So thank you all.
Thank you. And Dr. Price will be in touch with you about that. Thank you. And goodbye, everybody. We'll see you Thursday. Thank you. Bye.
Thank you.